Good afternoon. The Court Improvement Program welcomes you to Back to Basics, Abuse and Neglect Proceedings 101, our second cross-training session of 2021. The topic today is the adjudication hearing and improvement periods. My name is Kristen Antolini, and I am joined today by our presenters, Teresa Lyons and Natalie Sal. Both Teresa and Natalie serve as guardian ad litems as well as counsel for adult respondents. Before we get started, just a few housekeeping items. For our attorneys, today's presentation provides 1 hour of CLE credit. The provider is the Supreme Court of Appeals of West Virginia. For our social workers, today's presentation provides 1 hour of CEU. You will be able to find the CLE and CEU code at the end of our online survey, and I'll also announce the CLE code at the end. The link to complete the survey will be provided in the chat box. And we will also send an email with the survey link and a copy of our PowerPoint presentation following today's session. Your feedback in our online survey assists us in planning future sessions. Our next Back to Basics seminar will be on Friday, April 30th at noon. The topic is the disposition hearing and permanency planning. We ask your kind patience if we encounter any technological issues today, as we are recording from all over the Mountain State. We encourage you to utilize the chat function to both ask questions and provide resource information for your colleagues. Please choose the Everyone selection and send your comments to all so that we can all continue the discussion of abuse and neglect and the basics of adjudication and improvement periods together. Finally, please note that our session today is being recorded. And as noted, our topic today is the adjudication hearing and improvement periods, but we're also going to step back for a moment before we dig into that and talk just a little bit about the statutory definitions, just kind of as a baseline to get us started. And Teresa, could you help us just kind of help us find where these statutory definitions are in the code in case we ever need to reference those? And then also, if you could share with us a couple of key definitions for today's presentation, that would be great. Teresa? You're muted, Teresa.
As usual, with regard to helpful code citations, there's a chart at the beginning of the bench book that outlines the most commonly used code sections for abuse and neglect cases. And it's there, it's a handy reference, and it's also good. We've put it in the presentation because it's so helpful, and it's just a quick reference. With regard to statutory definitions, we want to talk a little bit about why the department, or the basis for the department to intervene in a family. And the department only has the right to intervene in a family based upon allegations of abuse and neglect. So the first question is, what is the definition of an abused child? And that's an injury to a child, or if another parent knowingly allows someone else to injure the child. An abused child can include a child who's subject to excessive corporal punishment. Essentially, it's any non-accidental trauma visited upon the child. And it's not surprising that sexual abuse and sexual exploitation are part of the definition, although these are a minority of the cases, thank goodness. However, they are included in the definition of an abused child. If a parent tries to sell a child or actually sells the child, that's also the definition of an abused child. And finally, domestic violence is a common form of abuse. With regard to that, it has to rise to the level as defined in Article 27 of Chapter 48. It's not just, it's not a real broad definition. It is limited by that code section. Okay, and the next thing we want to talk about, next definition, is the definition of a neglected child. And it's helpful to remember that the vast majority of these cases involve neglect, not abuse. So it's important to remember what a neglected child is. It's a child who's without food, clothing, shelter, medical care, education, all those things that you need, but it's not due primarily to a lack of financial means of the parent. If it's just a financial issue, the obvious way to cure the problem is to just do a referral for resources. A neglected child can also be a child who's without those necessary things because of the parent's absence. And that may be their voluntary absent, or it may be involuntary, such as incarceration, or perhaps a parent has gotten extremely ill. That happens every once in a blue moon. So that's the definition of a neglected child. The next hearing, that after a preliminary hearing, is the adjudicatory hearing. And there are some just basic key questions that are asked at the adjudication. And the first question the court has to answer for the case to proceed is the child an abused and or neglected child? The second question, if the child is abused or neglected, which parent or parents, is it one or both, are the abusing or neglecting parent? And finally, is the parent a battered parent? And again, a battered parent is a defined term and is raised in issues of domestic violence. Now, what I would say about adjudication hearings, that people think of adjudication hearings as being the big part of the case. For most cases, however, because they most involve neglect, the adjudication is not as important as maybe improvement period hearings or dispositions. So again, it's important. It's an important step. However, it's not the important step in the case, the most important case. Because many cases involve neglect, and the real question is what to do about the abuse or neglect. Many parents opt to stipulate, and the question is, what is a stipulation? And there's a rule on that. There's rules on many things in abuse and neglect, and it has two parts. First, there have to be some agreed upon facts that support court involvement, and that support the respondent's problems, conduct, or the conditions of abuse or neglect. And then second, there has to be a statement of a respondent's problems or deficiencies to be addressed at final disposition. Those are really the two parts of a stipulation.
And then, Teresa, we've got on the screen, you know, a draft stipulation to kind of look at. And this is just kind of an idea of what a stipulation looks like. It's certainly not the end all be all of stipulations, but maybe you want to share a little bit about just kind of the parts if counsel is trying to draft one of these.
Okay. The first thing that you want to look at is you want to identify the adult respondent. Again, the adult respondent identifies the facts basically that they're agreeing to, and then they identify the conduct that led to the case, and then finally they agree that it constitutes child abuse and neglect. And then second, The second part is the respondent identifies the problems or deficiencies to be addressed at final disposition. And this is very important because it's going to drive the case. It's at the end of the case, you're going to look at, did the adult respondent address the identified problems or deficiencies at final disposition?
And Teresa, for the court to accept a stipulation, what has to happen?
Well, first, the respondent has to be doing this in a knowingly and voluntary way. So typically the court will ask the adult respondent, do they understand their rights? Do they know that this is going to result in a finding that they're an abusive or neglectful parent? So that's very important. Sometimes the judge will ask an adult respondent if they're under the influence of any controlled substance. So it's very similar to what the court will ask about pleading before they accept a guilty plea. Now, the stipulation has to be in the child's best interest, and it has to meet the purpose of the rules and the statutes for abuse and neglect cases. If somebody offers a stipulation that really doesn't address the heart of the problem, I think that's a situation that would not meet the purposes of the rules and the statutes.
And Teresa, when someone is maybe looking at doing a stipulation, does a respondent have to admit to every single fact that's in the petition?
No, there are many times that there might be a contested fact or an inaccuracy, and a respondent doesn't have to admit to everything. A respondent simply has to identify facts that are sufficient to result in a finding of abuse and neglect.
And what if someone comes to court and they want to provide an oral stipulation? Is that permitted under our current case law and rules?
No, I don't. It is not permitted under our current case law and rules. And typically, I've seen if someone comes to court like that, the court will recess the hearing and allow counsel to prepare a written stipulation, and then bring the parties back to address the acceptance of the stipulation. So it's important to prepare ahead of time.
And then if a party does not want to stipulate, what is the alternative? And can you tell us about that alternative?
Well, the alternative is that there can be a contested hearing, and that means that, of course, that the department is going to put on its case, as well as the guardian ad litem, and the respondents have the opportunity to put on contrary evidence. The first thing to remember is the department has to prove by clear and convincing evidence that the conditions that existed at the time of the filing of the petition constituted abuse and neglect. Again, it's not a preponderance of the evidence, and it's not proof beyond a reasonable doubt. It is clear and convincing evidence. And as I had mentioned before, all parties have the right to be heard, and they have the right to present evidence and cross-examine all witnesses. Now, the rules of evidence apply. I would say that relatively loosely. However, it is important that counsel can raise hearsay objections and other kinds of objections during an adjudication hearing. Go ahead. You go ahead.
Yeah, then what happens at the conclusion of the hearing? What does the court have to find?
At the conclusion, the court has to make findings of fact and conclusions of law as to whether the child was abused or neglected. If applicable, the court may find that only one of the parents was an abusing or neglectful parent. The court is also required to consider whether a parent is a battered parent because he or she did not knowingly allow the abuse.
And what are some other really important things to remember in conjunction with an adjudication hearing?
Well, going forward, it's important to remember that a substantiated child abuse finding will limit employment opportunities in the future. Specifically, people are precluded from working with as CNAs with the elderly, and or daycare. Those are the most common employment situations that are affected if somebody is in fact found to have been an abusive or neglectful parent. If the parent is found not to be abusing or neglecting by the court, then he or she can challenge the substantiation in an administrative proceeding with the department. People have been allowed to do that before. However, there's a relatively new statute, 494601 little b, that allows for that specific situation if a court does not make a finding of abuse or neglect. And finally, a parent can appeal an adverse finding at adjudication. Usually this arises when a parent has abused a child to the extent that the case for the parent will be pretty much over if a finding of abuse or neglect is made by the court. So a parent can appeal at that stage, and the Supreme Court does look at that situation. However, the vast majority of abuse and neglect appeals are finding appeals made after disposition, not at this stage of the proceeding.
Teresa, we have a couple of good questions in the chat that I wanted to ask you if you would be willing. So the first one is an answer to the petition required? And if so, when it is best to file, let me try this again. If an answer to a petition is required as by statute, but the respondent wants to stipulate versus someone who wants to adjudicate, should an answer be filed? The question is basically, in practice, it seems that folks are not filing answers, but the statute certainly requires that one be filed.
Yes, the rule requires that an answer be filed. And my recommendation is know your jurisdiction. And so with regard to that, if you're in a jurisdiction where a judge wants an answer, my advice is to provide that answer and file it. You can, however, it's important to remember that the petition may not be taken as confessed, and that's kind of a term of art, which means that there has to be either some sort of finding by the court and or representation made by an adult respondent, and that's done via a stipulation. So I would do, if you're in a jurisdiction that holds people to the requirement of the statute, I would file an answer even if you're going to stipulate.
And another question, Teresa, is how often do you find that courts make the finding of a battered parent?
I would say that courts don't make the finding of a battered parent all that often. And it's just been my experience. However, there was a recent case, I believe HM, that came out it didn't come out this term, but in the spring term, that really raised that issue that addressed the issue when Respondents Counsel had raised that the court should make a finding of a battered parent, and the court did not make that finding, and the case was remanded.
Thank you so much for Teresa for joining us today. We are going to move on to improvement periods, and Natalie Sal is going to be presenting for us. So Natalie, what are the types of improvement periods available to respondent parents?
Well, the types of improvement periods that are available are a pre-adjudicatory improvement period, a post-adjudicatory improvement period, and a dispositional improvement period, and they all occur at different points during the proceedings.
And if someone is going to be asking for an improvement period, what is kind of the prerequisite for obtaining an improvement period if you're an adult respondent?
The purpose of an improvement period is to be able to work with services as a team, and then individually the respondents to work with services and be able to remedy the conditions of abuse or neglect that existed. To be able to get to that step, the first step is an acknowledgement that there was abuse and or neglect of the child or the children. And there needs to also be an identification of the abuser, whether it be the respondent or another person in the respondent played a role in that, allowing that child abuse or neglect to occur. So in working with respondents, sometimes they can be very hostile to the system. Sometimes it can be difficult to help them to understand that all of these providers who are coming in and offering them services are part of their team. This is a remedial type of proceeding. This is not meant to be a punishment to them. And so as a remedial proceeding, it's important that they acknowledge what the problems are and they're honest about that with the team and with themselves so that they can begin to take those first steps and really engage with services.
So just to get us started, can you tell us what is a pre-adjudicatory improvement period and what are the parts of that?
Absolutely. A pre-adjudicatory improvement period, and you can see in the slides that these are covered in West Virginia Code 494610. Pre-adjudicatory improvement periods occur prior to an adjudication, prior to a judicial finding by clear and convincing evidence that there's been child abuse or neglect. Pre-adjudicatory improvement periods can be requested anytime up through the point of adjudication. And actually, there was some case law, although I'm not sure how well some jurisdictions would follow this at this point. It was fairly old, that would even allow a request for a pre-adjudicatory improvement period after adjudication had commenced, but not completed, no finding. A court in a pre-adjudicatory improvement period can grant a 3-month period of time for the respondent parent to work with services. Unlike the other later improvement periods, there's no possibility of an extension of that 3 months. It's an incredibly short period of time to be able to work through services. And because of that, there are really limited issues that are appropriate for pre-adjudicatory improvement periods. It's not generally appropriate in cases with substance use addiction, for example, because that takes a lot longer period of time to be able to remedy than 3 months would normally afford. But you have to look on it as a case by case kind of consideration and analysis. To be able to get an improvement period, you have to file a written motion, and you have to demonstrate that the respondent is going to be able to fully participate in that improvement period. The burden is on the respondent to prove that by clear and convincing evidence. So when you're drafting those improvement periods, you really want to be able to highlight what the respondent has done up to that point that demonstrates they're going to be part of this process and that they're really going to engage and try to make some changes. The court is required to review the progress of that improvement period, either at the 60-day mark or at the 90-day mark. But if it's at 90 days, they expect to have a report from the department 60 days in so that the court and the parties can assess the progress in that really short time period.
And then our next one, of course, is the post-adjudicatory improvement period. What's kind of the difference between the pre and the post, Natalie?
In a pre-adjudicatory improvement period, recall there's not been a judicial determination of abuse or neglect. Well, when you get to a post-adjudicatory improvement period, there has been a judicial determination of abuse or neglect. This improvement period also affords a much longer time period. It's up to 6 months, and there's the possibility of a 3-month extension to that if there is a finding that the respondent has been fully engaging and that they are making good progress and that they are changing the circumstances that brought them into this case. Again, they're still required to file a written motion. They're still required to affirmatively demonstrate by clear and convincing evidence that they're going to fully participate in this improvement period. If they were granted a 3-month pre-adjudicatory improvement period, it's harder. They've got one more hurdle to overcome to be granted a post-adjudicatory improvement period. Specifically, they have to show a substantial change in circumstances to be able to get a post-adjudicatory improvement period if they've already had a 3-month improvement period prior to adjudication.
And then finally, of course, we have the dispositional improvement period. How is that both the same and different to the post-adjudicatory?
The time frames are the same. Again, it can be 6 months with up to a 3-month extension that's available. And this is an improvement period as a disposition. That language is really pretty important. This is not an improvement period that looks to the idea that you're going to have the availability of more improvement periods down the road if you continue to show substantial changes in circumstances. This is as a disposition, and that gives this some finality. You're still required to file a written motion, still required to demonstrate by clear and convincing evidence that the respondent's likely to fully participate in the improvement period. And if the respondent was previously granted any improvement period, they've got to demonstrate a substantial change in circumstances to be able to be eligible for this improvement period. Now, like a post-adjudicatory improvement period, there are requirements that there be court reviews, judicial reviews of this. And with regard to both post-adjudicatory improvement periods and dispositional improvement periods, there are judicial reviews at the 90-day mark, and there are going to be judicial reviews at the end of the improvement period. There are also other options for having a different time frame with court summaries provided within that time. But generally what you're going to see is you're going to see these reviewed in the courts that we practice in, and I think most of the courts statewide, before the judge every 90 days either way. If there's going to be a review at 90 days rather than 60, again, there needs to be a court summary, a document provided by the department to the court at the 60-day mark to give the court an update. But generally, you're going to see these reviewed every 90 days.
And Natalie, when does an improvement period actually begin?
An improvement period actually begins the date of the hearing that it occurred, not the date that the order is entered. Now, something to keep in mind is you don't have to begin services on the date of the beginning of the improvement period. Services can begin before the improvement period officially begins. And there are some cases where you have very motivated respondents, or you have problems that you know are going to take a while to begin to remedy, where it's wise to begin services before you get to that point. But nonetheless, officially the time starts ticking on the date of the hearing in which the improvement period is ordered. And when you look at all the time periods from the date that the timer starts ticking through the end of when you've run out of time, all of those improvement periods together cannot exceed 15 out of the most recent 22 months unless there are compelling circumstances that are found. Clearly, there are those circumstances that occur, and if courts find in a given case that it's in the best interest of the child to exceed that circumstance, or exceed that time frame rather, because of compelling circumstances, that can be a legitimate finding. But most cases really need to fall within that 15 out of 22 months.
And then can the start of an improvement period be delayed? Let's say that dad is incarcerated or mom is an inpatient, can we delay the improvement period to give them a little bit of extra time?
The Supreme Court says, no, we cannot do that. Now, as a matter of practice, I have occasionally seen judges do it, but they really are not supposed to do that. The circumstances in which I have seen that generally are where children are either placed with family members, or there is another parent who's on a different track. They have not delayed their improvement period. They are on a reunification track, and there's no delay in permanency to the child. But generally, the Supreme Court says, no, you may not delay the start of an improvement period. That time starts ticking, and there are not many things that stop that clock. The court also really needs to not put off ruling on motions for an improvement period. Now, certainly there are reasons to continue hearings. There are good reasons why a court may delay for a short period of time to announce findings. That's not really what the Supreme Court is addressing. The Supreme Court is addressing situations where courts artificially build in extra improvement period by delaying on the ruling, and the Supreme Court says, no, the courts really can't do that, and we're not supposed to ask them to do that.
And Natalie, just as a question that we just got in the chat, talking about the length of time of an improvement period, what do you think, or what have you found in your practice are compelling circumstances to justify extending improvement periods beyond that 15 out of 22 month mark?
Those compelling circumstances can take a lot of different shapes. I have seen courts find compelling circumstances when a parent who has had a severe long-term substance use disorder goes to long-term treatment, and that long-term treatment is a 9 to 12 month program, and they're really pushing some of those limits but doing extraordinarily well. They've got an aftercare program. The court will sometimes find compelling circumstances if really the only thing left is to try and start that transition back to that parent who has demonstrated long-term sobriety. I've seen exceptional compelling circumstances in cases where we have parents who have done everything they're supposed to do, but the children are still doing a little bit of work. They're trying to work toward getting reunification done, but we're not quite there. We still need to be a little more gradual about the visitation and increasing the visitation and moving it to unsupervised and overnights, to buy a little bit of time to make sure that process is moving at the child's pace instead of at the parent's pace. Courts have found compelling circumstances. I have also had courts find compelling circumstances when you have children, particularly older children, who are very, very strongly bonded to parents, and parents are making progress, but it's slow. The courts, in my experience, have sometimes found compelling circumstances to give them a little extra time because everybody is making progress, but the circumstances and best interest of the child would warrant giving them that extra time.
So when we're looking at, what are the terms of the improvement period going to be and who's making those decisions, let's first look at who actually helps determine what the terms and conditions could be. And in my mind, that's usually the MDT. Can you talk a little bit about the MDT process, who's a member, and then how they assist in developing those terms and conditions?
Absolutely. So the MDT is absolutely critical and the primary mover in terms of determining what an improvement period looks like. Now, that's not to say that judges are not going to include terms and conditions. In fact, they do and are required to adopt terms and conditions of improvement periods when they grant them, but they rely on the MDTs to not only put the details into some of those larger terms and conditions, but to look at the family more closely and look at the children more closely and decide what types of terms and conditions are going to lead to the right types of services that are going to help this family get to where they need to get to remedy the conditions of abuse or neglect. So having an active MDT where everyone has a voice is very critical in addressing the needs of every family. every circumstance is going to be different. There are key players, though, in every case. And some of those key players are going to be the department workers. They have to be there. They have to be engaged. They have to know what's going on and be able to work with the rest of the team. The respondents and their counsel need to also be active members of the MDT. One of the things that I've learned about representing respondents is very often they feel like they are powerless in this process, and they have some hostility toward the members and toward the process, and they're skeptical that they're ever going to get their kids back. Being able to help them engage actively in developing the terms and conditions of an improvement period and engage actively in the MDT process can be very empowering for them. And so helping them to understand that they can help drive that boat to some extent is a really key part of that relationship with respondent clients and a key part of their success, because they tend to want to own it more if they're not being told what to do, but they're part of a team developing a plan. Co-petitioners and guardians, parents, and kinship placements, folks who have a direct line to what's going on with the children and what their needs are day to day, they are critical in these types of situations as well, which is why they are a critical member of the MDT. Having the prosecutor available for the department is also very important. There are times when policy will sometimes clash with the needs of the family or with the process and trying to get the services in place. And that's not at all a criticism. It's helpful to have the prosecutor there to help problem solve those situations so we can figure out how to work around those and make sure the family, the parents, the children all get what they need while not forcing the department worker to be in an impossible situation, for example, with payment for things that the department would not ordinarily pay for unless court ordered. That's one example. There are others. The guardian ad litem has to be part of the MDT process and has to be an important role in being able to put together an improvement period. They should be the ones who are in that process advocating for the needs of the child and making sure that in creating all of these terms and conditions that the parents are going to have to follow, that we are not forgetting the fact that these kids often will need services themselves. They're often going to need therapy services, sometimes diagnostic services with psychiatric or psychological evaluations. They're going to need medical services and developmental services. The list goes on. And those also need to be part of what the team is doing. Ultimately, if you have a child who has extraordinary medical, psychological, developmental needs, then learning about how best to meet those needs will become part of the terms and conditions of the improvement period. You can't have parents who don't understand how to take care of those extraordinary needs and have a child coming home to them. So all of those are important things that the guardian ad litem really needs to be able to assist with. Looking at foster parents and agencies, for the same reasons I've just talked about, it's important since they're working with these kids day to day, they know what their needs are and they can speak to those needs so that the team can meet them and so that the terms and conditions of improvement periods are going to be tailored to address those needs. CASA is critical. I wish we had a CASA in every case. I know we don't have those kinds of resources or coverage, but they can be incredibly helpful too in looking at things, stepping back and looking at things with a common sense view and with an eye toward what the children need and being able to make recommendations as well. And the more, and I would call them ancillary support MDT members that you don't see at every MDT, you don't see them every time, but they can be also critical in the right case. There are folks that you want to reach out to, and if they're available, please, bring them in because they can provide guidance and insight. And those are going to be teachers, school administrators. Service providers are very, very important in the MDT process, both to, again, problem solve, to provide updates on progress, and to provide additional insights into what may be helpful for the parents, what might be helpful for the children, and what we can do to problem solve from a common sense standpoint, because they're seeing the interactions on a regular basis. It's also helpful to bring individual therapists into that mix. And I'm sure that you can think of other individuals in different cases where it would make sense to reach out to them. The MDT process can include other ancillary support members without requiring them or asking them to be at every MDT. If it makes sense to have a child's teacher come and talk about issues, then plan to have them join for an MDT or two as they are needed. And that can be really helpful, having those ancillary support members in and out of the MDTs as the case needs.
Natalie, there was some discussion in the chat while you were presenting about someone feeling like the department is the sole entity that's setting the terms and conditions of an improvement period. Can you talk maybe a little bit about really what role counsel for the adult respondents can play in formulating those, as well as the guardian ad litem and the other team members, and also just, you know, if someone isn't part of that MDT process that maybe should be at the table, who can invite them to help formulate those terms and conditions?
Those are great questions. And when you are in the context of the MDT, you can and you should have a discussion with the department worker about what you believe, if you are respondents counsel, what you believe your clients might need. And on the other hand, if they are requesting services in a cookie cutter fashion because they do, let's say, adult life skills with every single client, no matter what, and you believe your client doesn't need that, you can also have a discussion about why are we using the resources for that service when what they really need is something different. That should be a discussion that is had at the MDT table, and it should be a discussion where everybody has a voice in that. There should not ever be a circumstance where the department is setting the improvement period terms and conditions, and they are the only ones who are setting those. Certainly, they have the right and they have an obligation to set up services. They have an obligation to set terms and conditions that they believe are reasonably calculated to help each respondent be able to remedy the conditions of abuse or neglect. But everybody should have a voice at that table. If there is a challenge in getting everybody together on Zoom or whatnot right now, then certainly as respondents counsel, one thing you can do is you can reach out to the rest of the team via email, and you can let your client's voice be heard in writing if an MDT is either too short or you don't have one set up or whatnot yet. You can do that early on in the process. I would encourage respondents counsel to also reach out to the guardian ad litem and start a conversation with them as well about what they believe the services that need to be implemented are, what they believe the terms and conditions of the improvement period need to be, and have that as a discussion. I would encourage them to reach out to service providers as services are getting started to see whether or not those services need to continue, whether the parent has completed them, or what the status is on those. It should be an ongoing conversation as time goes on. With regard to the guardian ad litem, certainly I would encourage you to stay in close contact with the department, with respondents counsel. You're going to be the one looking at the situation and making recommendations as you get close to the end of the process about whether or not these parents have substantially remedied the conditions of abuse or neglect. And if you don't have a good plan in place, a good roadmap for them to get there, then it's going to be very difficult for them to meet that goal. And frankly, if they're able to meet it, then it's usually in the best interest of the child to try and reunify with them. So if you are not doing something to help make sure that the roadmap is in place, then I think you're not doing your full job. So I think that those things are all important. Just talk, send out written lists of what you believe might be helpful, and do everything you can to communicate. Otherwise, the department is left with their obligation to make these terms and conditions and to set those forth, if they don't hear any other voices, they're going to do what they have to do without those other voices.
So Natalie, I think it's helpful, and I think that you would agree, to have the terms and conditions in writing, whether it's through an order, whether it's through a letter, or whether it's through something like what I've put on the screen. And this comes from the Fifth Judicial Circuit from Judge Ashley, where they actually create this chart and list out all of the possible terms and conditions of the improvement period, who will monitor it, and then they follow that progress and make notes, and they file this actually in the court file. But there are, of course, many different formats that can be used to put this in writing. But with that in mind, Natalie, what are some good terms and conditions for us to think about when formulating the improvement period requirements?
Well, first of all, let me just circle around to putting these in writing. Whether you use this particular form, which I think is a very workable form to use, or some other form, it is critical that those be in writing. Part of the reason it's critical is because as the case moves on, issues will come up, things will change. It is important to keep our eye on the goals. Now, sometimes those goals may change as we find more information and as parents are growing in terms of their services and learning and making progress, but it's still really important to keep our eye on the goal of each of the services, the goal of each of the terms and conditions in the improvement period. It is also really critical to be able to put each of these terms and conditions in black and white in front of respondent parents. They will sometimes feel like they are very cut adrift. And even if they are told you are required to do A, B, and C, and the judge says you're required to do A, B, and C, I can tell you that most of my clients will remember A and maybe part of B. And it's not because they're being difficult. It's not necessarily because they are low functioning, although some are low functioning and need some extra help, but they are in a stressful situation. It is in a situation where there's a lot going on. People are talking a language that is unfamiliar to them, and they are being expected to do things which, if they were able to manage their life well, if they were able to work through the problems that led to the removal of their children on their own, they would not be in the circumstance. So they need that extra help. Putting these in writing for them so that they can see them and going over those with them one by one so they understand them, and then giving them that paper to take home and look at, that can be incredibly empowering and helpful to them. In terms of what terms and conditions will you see in most improvement periods, keep in mind there are no cookie cutter cases or families. They're all going to look different. But most of the ones that I see these days are going to include a psychological evaluation. It's very helpful to find out if there's some underlying issue that can be helped through either therapy, through medication, through a combination of them. I also see in most cases, in most courts right now, drug testing, and I'm seeing that even if substance use was not an initial allegation, because it is just so pervasive right now. There are so many families that are struggling with this. And if it turns out that there's a parent who is not using substances and they're testing clean for a while, most judges will then relieve them of that obligation. But I'm seeing that in almost every case. Terms and conditions that will help the families and help the parents commonly are going to include parenting, and that parenting education really should be with service providers who are going to meet the parents where they are and look at the family where it is. It's not a matter of just handing them a booklet and going through what's in the booklet. It's a matter of talking with the parents and giving them some real life advice and some real life education about how to deal with situations that arise when you have kids that are at the developmental level and with the issues that their children are having. And sometimes it's very, very basic parenting and you work toward that goal. And other times they have some of the basics down, but they need some help moving through some of the more advanced work. I also see adult life skills coming up a lot, and that's hard sometimes to assess when you have parents who have substance use disorders because it's hard to get a baseline. Most folks, if they are using very heavily, they are not engaging in good decision making, whereas when they were clean, or if they are clean for a period of time, they are making better decisions and they have pretty good life skills. But adult life skills, it's like for them, in addition to the educational component, in addition to the support component, it also is providing to them a way to have some modeled life coaching that they need and that would be useful to them. And I see a lot of those types of services. Keep in mind, though, that you have to think outside the box. Those are, when I say cookie cutter, those fit a lot of families, but there are other services that may fit the families you work with better. Take a step back and ask yourself, what can help them get from point A to point B? And how can I find a service within the community and get that service to them? Whether it's service to help them with domestic violence issues, whether it is a service to help them with housing, whether it's to help them clean and organize. Look into the community and look for ways to solve problems rather than just plucking the types of services that are commonly used. And Kristen, if you're talking, you're muted.
So we're, sorry about that, I was muted. We are almost out of time, but I just really quick wanted to make sure we get in these last 3 questions. And I would encourage folks in our slide to check out the matrix that I provided from the 5th Judicial Circuit as some additional ideas for terms and conditions of improvement periods. And I also really encourage everyone to put in the chat real quickly some things that they're using in their area. Finally, Natalie, who is responsible for the initiation and completion of services?
It's the respondents. They are always responsible for the initiation and completion of services. So if there is a situation where a department worker is extraordinarily busy, can't get that referral made, things like that happen, keep in mind as respondents counsel that you are doing your job by helping to sort of pick up the slack and help your clients understand they have to make the changes, and the team is there to support them, but they have to make the changes. Get in there with them and do what needs to be done to help them get their start.
And are respondents required to execute a release from medical and mental health services pursuant to the improvement period statute, Natalie?
They absolutely are. And I think that's an overlooked part of the statute sometimes. But when you see courts order that respondents execute that release, they are not just ordering that from their court as part of what their practice and procedure is. The statute really does require that respondents execute that release so that the team and the court are able to get records that are necessary to assess what their needs are and how their progress is moving. And also those releases are required to be accepted by providers of those services, be it health, mental health, and whatnot. So with regard to those, the facility is not allowed to say if they receive this kind of a release that's signed by one of their patients, they're not allowed to say, look, it's not our release. They do have to turn those records over. And hopefully that can be helpful to some of you who may have been butting your head against the wall trying to get records from places. I do want to say one thing about improvement periods being terminated and address one quick thing that Pam Kaler posted as well. But with regard to improvement periods being terminated, they can be terminated. Judges will terminate them if an adult respondent is failing to participate. And as guardian ad litem, it is really incumbent upon you, if you know that parents are not participating and they truly don't seem to be making any progress and people are just spinning their wheels, it is incumbent upon you to go report that by way of a motion to terminate that improvement period, because at that point you are allowing time that is very precious to a child to be wasted, and we don't want that to happen.
Natalie, thank you so much for joining us today. Thank you to Teresa, and thank you to everyone who has joined us as a participant today. We appreciate everyone who serves our children and families in this great state of West Virginia. Please remember to complete our online survey. I posted that link in our chat, and our CLE course provider number today is 5 4189. And we look forward to seeing everybody on April 30th at noon for disposition and permanency planning. If you have any questions for our panelists, they'll stay just an extra couple of minutes and respond to those in the chat. But otherwise, we look forward to seeing you on April 30th. Thank you and have a wonderful day. Bye-bye.